Hi, this is Gary Jordan for Natural Law for North America, and this is the second video of a series to show the roles that that people play in a natural law court. This video will address prosecutors and defendant. Like with the judges, you could be a prosecutor or you could be a defendant. They have several things in common and several things that are different. They have in common, obviously, one thing is that they're not licensed bar association attorneys. You do not need, or probably don't even want, someone who spent years in law school learning all the nitpicks of legalism of the old system. Natural law has stated many times it's simple enough a child can understand it. So you don't need all that. They can be a man or a woman. And usually the recommendation would be that they are ahead of, they're the spokesperson. They're the person that goes in the court room or the court, wherever you hold the court, whether it be in a building or outside. They're the one that addresses the judge, addresses the other side, calls the witnesses, presents evidence, and cross-examines the witnesses from the other side, and cross-examines the evidence that's necessary. They both have the responsibility to do their investigation prior to the trial. Unlike a common law, English Roman law type court system, natural law trials are not fishing expeditions. They're not meant to do that. So the prosecutor and the defense must do their homework, as they say, before the trial. With that, we'll get into what each side's responsibilities is and what their job is to try to do. Now, we'll start with the prosecutor. The prosecutor is the person that either is the victim of a crime, who is bringing charges against someone who had committed a crime, or is said to have committed a crime. Or that person is a representation, an advocate for a victim, say a child, a mentally disabled person, someone in a hospital that's incapable of, or dead, that's incapable of doing this for him or herself. There's a number of reasons why, or someone just doesn't have the communication skills or the ability to call witnesses, to do their investigation. The first part of a trial, once the trial starts, is that prosecutor has the job of demonstrating that injury or other types of harm has happened to somebody, to them or to their person that they're advocating for, or they're representing in the case of a member of their family or whatever. They have to show injury, because under natural law, there is no crime unless there's a victim. So you first must show that there is a victim to show that there is a crime. Once you've successfully demonstrated there is a crime, it will be helpful, particularly later on down during the restitution phase, to show what kind of injuries, what kind of harm was caused, and the extent. So as to make it easier for the judges or jury to develop a restitution, develop healing actions that the defendant can take once if proven guilty. Once you have gone through the process of demonstrating there is an injury and the type of harm caused. Your next job, your next task, is to demonstrate that the defendant that you have accused of causing the harm is in fact responsible. Now that doesn't mean that he or she is 100% solely responsible, just responsible. There may be 4 kids, 4 older people beating up, somebody. If you show that that person that you're accusing was one of the 4, even though you can't find the other 3, you still can at least deal with that. So that's the job of the prosecutor. And they worked with the judge in the remediation phase, especially. He worked with the judge, the defendants, and his or her representative, and any other involved community members that might be affected by all remediation to devise a remediation that is genuinely healing to all parties. For the defense side, the defense is the person who is accused of a crime. Like with the prosecutor, that person might be represented, the defendant might be represented by a family member or another member of their clan due to being a child, inability to communicate well, or other factors that would not allow that person to be an effective running his or her own defense. That defendant still needs to be present. That defendant still needs to be held accountable, and that defendant still needs to have the opportunity to address the plaintiff. And the plaintiff, the actual victim, must have the opportunity to address at some point in the procedures the defendant. And that can be very emotional, and this is where the judge has to keep order, judge or judges. Now, the defense has one primary job: to demonstrate that he is or she is not the cause of the harm. If he or she is the cause of the harm, then he or she or the representative he works through must address the harm caused and make restitution. That's the long and short of each of their responsibilities. Thank you. Have a great day.